Good evening, everyone, and welcome to HomeBuyersConnect, a monthly educational initiative brought to you by India's first home down payment assistance program, that is Home Capital. At Home Capital, we believe in helping others accelerate their home buying process, while we also have our own products in this space. The primary motive of this webinar is to educate our The primary motive of this webinar is to educate our home buyers and smoothen out the entire journey for them. We all know that home is one of mankind's primal needs. Still, it is a complex and time consuming process, and it also remains to be the most expensive proposition. So, in this webinar, the series by Home Capital, every month, experts from industries guide and help us on how we can ease up the home buying process. What are the finances options available? How we can save up on our finances? What is exact process in the terms of home loans, down payments, stamp duty and registration, etc. But we do realize that the number of resources available out there is not generic, or it is. And to bridge the gap, let me introduce today's guest speaker, Advocate Sujata Angadi. So, she is a postgraduate in law with over 15 years of experience in corporate law, mortgages, and independent handling of litigation and non litigation matters. She has experience in legal compliance related issues in various sectors such as retail lending, investment banking, wealth management, retail and institutional equities, and insurance. She has strong research oriented and analytic skills and is a team player. She has received several awards and achievements throughout her career. Currently, she is co managing and founding partner at Law Veritas. Hello, ma'am.
Hi, good evening.
Good evening.
So,
Can you give us a
Vaishnavi,
brief introduction of today's topic?
sure, Vaishnavi. So, thank you for that quick introduction about me and my firm, Law Veritas. So, today's agenda, while Vaishnavi spoke to me and she told about the great initiative of Home Capital, I jumped into the opportunity and I would really like to share my knowledge on this field where real estate is a very important asset for most of us. We will have a very brief discussion about you as a home buyer. What are the areas which you should be careful before you purchase the property in order to avoid any surprises later point in time? So we'll walk through the points about the introduction and how RERA has now stepped in to protect all the home buyers and the due diligence that you should carry out before purchasing the property. The third topic will be what are the importance of occupancy certificate, which is a very important document. And in case in any of the properties that you are contemplating to purchase, what are the impact of litigation? Not all litigations are very, very dangerous, but at the same time, when there is a litigation on any property, how you could take a informed decision is what we will have, we can discuss. And at the end, we will try to give you some key takeaways while you purchase what you can do. So that would be the agenda for discussion for today. Let me know, Vaishnavi, if we are good to start.
Yeah, I'll start with the basic question. As you mentioned, the first point of RERA. What are the key provisions of RERA that protect home buyers?
Surely. So RERA has stepped into the picture because of the surprises or the difficulties the builders were giving to the home buyers. So the RERA brought in provisions which will help the home buyers to understand what the project is all about. While the project has a lot of complexity, not each buyer would have the sound technical information required, whether it is a legal or it is the approval processes or the construction quality. So RERA has tried to bring in transparency. So developer, the provisions which are helping buyers is the developer is bound to disclose all these information that I was just explaining and the title. So that's which is very important, Vaishnavi.
Okay. What is some of the risk associated with purchasing under construction or resale properties and how they can be mitigated?
Yeah. So under construction property has a big challenge about the date of possession. That's a very big risk that is associated with any under construction property. So the mitigation can be that RERA has its own provisions which is trying to protect this risk by providing penalty on the developer if he is not able to hand over the possession on the date committed under the registered agreement. And that's where the documentation is very important.
Okay. You mentioned due diligence. So, what are some of the due diligence steps that home buyers should take before purchasing a property?
Yeah. So, title being one of the very important aspect. Probably when we reach to the due diligence topic, I would like to touch upon there in detail. But most of the time, we all home buyers, including me, when I want to purchase a property, the first thing we look is for the view of the property and how does the property look, the locality, and that's it. I think we all stop ourselves there. But I feel we should all go a little beyond and have our clarity about the due diligence steps that we should check is what is the power of the seller who's giving the property to you, how did he get it, and the technical aspects that normally your completion certificate or the commencement certificate or your occupancy certificate will help you to protect you. Yes, Vaishnavi.
Yeah. So, how does litigation affect the rights of property owners and what impact does it have on those who intend to purchase a property?
Yeah. So in India, the law is very clear. When any particular property has any kind of litigation, ideally you're not supposed to touch the property at all. When you say touch the property, any kind of interest is not supposed to be created on that property. When we say in our language vesting of interest or any kind of interest or the rights being created, it can be by virtue of transfer or by giving a gift or by creating a mortgage. All this is prohibited under the law. So the impact of litigation on any property is very, very major. And when there is a written law, there is no ambiguity in the law. In that scenario, it's better not to purchase such kind of properties. Having said so, like I said in the beginning, there are certain situations where you may consider, but it all depends on case to case. So for that, it's always advisable you go by a legal expert or a legal professional to guide you on that.
Okay, moving ahead. What is insurance of occupancy certificate?
The importance of issuance of the occupancy certificate is such that again the provisions in the law are very clear. Of course, when if we have enough time and I'll be able to reach to that slide, I will explain you what the provisions are explaining and what are the requirements. Without OC, ideally you're not supposed to occupy the property. OC is the short form of occupancy certificate for the people who don't know. You're not supposed to occupy the property. That's what the law says. Having said so, we all understand there is a gap between the legal requirement and the practical situation. So that's where we try to help you bridge the gap. But ideally, occupancy certificate is a very important document. Do not go ahead purchasing a property without that. Under construction is a separate situation. Yes, Vaishnavi.
Okay. Ma'am, you were supposed to show the presentation. Can we begin with that?
Sure, let's do that. I'll try to share my screen. Is the screen visible, Vaishnavi?
Not yet.
Now is it visible?
Yeah, it is. Yeah, it is.
Okay. But probably I'll have to send this across to you because there is. Should I send this across to you, Vishnavi? There seems to be.
Yeah, sure, you can.
Okay. Would you be able to play the screen slide there from your end?
Yeah.
Well, in the meanwhile, while that technical issue is sorted out, I would like to just bring a point in front of all the home buyers. Either one, a few of you must be already holding certain property, or it may be a dream property that you're looking forward for. Uh, there's a famous saying from Mr. Franklin where he once quoted that a real estate is an investment which is one of the most safest investment. It cannot be stolen or it cannot be lost, provided you have done your basic due diligence. So with that, we would like to begin the discussion where basic common sense is taken care, that is required before purchasing of the property, taking help from the experts before purchasing of the property to make sure that your due diligence has been taken care of, and the consideration is paid in full, and then you take care of the property. So that makes one of the best way of making an investment. Coming to the Vaishnavi, any, let me know when you're ready to share the slide.
Yeah, the slide is ready. Once you're done, we can start.
Okay, you can start playing the slide then.
Okay.
Sure. So the idea to discuss with you where Home Capital has tried to bring this platform for all the prospective home buyers to get an understanding what can be the idea of a perfect home. Perfect home, while I was mentioning only view is not important, having a good view is not important. What is also important is to make sure that it remains a pleasant experience throughout your life and for your next generation to whom you would want to pass it on. So for that, the agenda, what we discussed in the beginning is while Vaishnavi has already taken care of the introduction part and she's already touched upon a lot of points in the beginning. She had few interesting questions, which I tried to cover up in a short time. We will walk you through with the RERA protections, the due diligence aspect that is required, the importance of OC, and the litigation impact. We can go to the next slide, Vaishnavi. The next slide. So, what has RERA brought on card for all the home buyers? The transparency that the developers were not very happily sharing earlier. Now, post RERA, this has become a big, very, very important tool for the buyers, because if there is transparency, if there is information being disclosed, Vishnu, I think the slide has gone. Yes, thank you. So transparency brings in a lot of power to the buyer. So you have a negotiation power when there is information available in your hand. So because the developer is now mandated under law that he has to first get himself registered under RERA, second, make a lot of disclosures which are very important for you to take the decision. So that's the first tool or the key highlight of RERA that is a big help to the buyers. Secondly, defining carpet area. Now, this was something which the builder used to play around a lot earlier before RERA came into existence. Now, it is very, very clearly explained that it's the actual usable area within the walls of the apartment, and it is very clearly defined. So, there is no ambiguity around this point now anymore, and thereby you will end up paying only for the right amount. Of course, again, there is a little gap between the reality and the legal requirement, but at least you are in a position where the statute is on your side, the law is on your side. So this prevents any kind of misleading, wrong information. Many a times, if you see, you get a lot of messages on your WhatsApp or your SMS coming in from the builder's office, which says you will have 1,000 square feet property at a very low price of 1 crore in Mumbai. You can't even imagine that. But these kind of misleading informations can be at least avoided, or if they are doing so, you can at least take an action because it's against the legal provisions. There is something called as escrow account. So RERA has made it very clear, if the developer is taking any kind of amount as a booking amount, and then later on stage wise you go on paying for any amount, that has to be deposited to the escrow account only, so that there used to be a cycle of misuse of funds. Suppose Miss Vaishnavi is invested in a particular property, she's paid the down payment and she's doing slab wise payment. After reaching a particular slab, the developer puts the project on a standstill, and that whole money he uses for purchasing another land or another development rights, and thereby whatever money all the purchasers or all the allottees of that particular flat in that project had invested goes to another project which the builder is very excited about. But what happens to the dreams of the home buyer? That goes into cold storage. Now that is what RERA has tried to plug in, and they have brought in the concept of escrow account. With escrow account, the money is to be kept in safe and to be utilized only for the project for which they have raised the money. So that helps the home buyers. We can go to the next slide, Vaishnavi. Apart from this, like in the beginning we were trying to say, there will be a lot of us, like let's say for example, if somebody is a practitioner into medical field, that person we cannot expect to have civil engineers knowledge. So the quality assurance of the construction becomes a little difficult for a doctor or a medical practitioner to really understand what is the quality of cement he's using, what is the quality of metal he's using, which is required to be used. In that, RERA has brought in certain certifications that he is supposed to collect from the experts and make certain disclosures at different stages. And that's where the quality control has brought into as a tool to home buyers again under RERA. So the construction quality can be controlled. Plus, there is an assurance which comes in within 5 years after the date of possession. I would request all the home buyers to make a note of this. If there is any major issue which you can really prove and you can bring it up clearly, RERA has protected you. Within 5 years, you can claim for your damages or ask him to get the quality to an extent which is required by law. So that's a provision which all of us should be aware of, because awareness is very important. Without being aware, many a times builders do mislead, or they say that it's not in our hand, we have given you the possession, now nothing can be done. That's not correct. At least the law is protecting you, so please be aware of that. After all these protections, now RERA has tried to bring in a mechanism where it can address to your grievances, your difficulties. If builder's office is not supporting you, please feel free to go to RERA authority to get your issues resolved, your complaints resolved. Any kind of violations which are found are taken quite strictly by RERA authority. And now developers background check, developers reputation, all this is open, it's transparent, it's available on a website because of the RERA website being so good. I would encourage each one of you to please always try to check the RERA website before investing in any property. Many a times we do get a lot of cases where people come to us after they are invested. So it becomes a little difficult situation because your money is out of your pocket already. At that point, explaining anybody or trying to get their resolutions becomes a little difficult. So if you are putting your hard-earned money, you're investing, might as well please go to the RERA website, check the background, check the reputation that the builder is carrying, or the number of complaints is also nowadays available on RERA website. Kindly go through that. That helps you to take an informed decision. The refund and compensation mechanism has been made very seamless. Interest, how to calculate the interest. There is State Bank of India's lending rates, based on which, that's a benchmark basically, based on which the interest rates are calculated. Very clearly law has defined, so that you as a home buyer is not at the mercy of the judge or the lawyer who's defending your matter to decide the percentage. That's a very nice mechanism law has brought into the picture to make sure that the home buyer is able to get his relief as early as possible. We can go to the next slide, Vaishnavi. Here again, RERA has brought in protection for you because the draft agreements have been standardized by the government of Maharashtra under the RERA requirements, and the respective laws which RERA has brought in for different states also. Being a practicing lawyer in Maharashtra, I would be able to comment more on RERA requirements. but the drafts are quite standard, and it helps you to make sure that the details are captured well, and the title deeds are explaining the history of the property, how it has come to the developer. This safeguards your interest. Now, it's very important. When we go to the due diligence slide, probably I'll try to walk you through there more. But you, as a purchaser, has to be very careful. What are you purchasing and what is being recorded in your document? So many a times, what happens is we are so excited and so happy about the new home that we are purchasing, we land up forgetting what is the document all about, because that document is the only thing which is going to come to your rescue tomorrow if things go wrong. So today we are very happy because everything is going good, but it's the situation when things go wrong, you really are running here and there to get the right help. And this document is the one which is going to help you. So my request would be each home buyer should make sure that you have done your due diligence and you have made sure that you are safeguarding your interest for a time where you want to make sure the seller or the builder is ensuring what he's promised and delivering what he's promised to you. We can go to the next slide. So we have tried to touch upon these key highlights, but just wrapping it up again for the benefit of the viewers and the members who are listening to this session. Uh, RERA has helped you to establish a proper regulatory authority in order to ensure that your grievances are addressed to. It has made all the developers to do compulsory registration. Then escrow account arrangements has been made to make sure that the money is not siphoned out or the utilized in some other manner which is not supposed to be. And continual disclosure is something which is very important, wherein RERA requires that on stage, the stage as in the slab wise, whatever has been completed, there has to be certification being obtained from expert, and that certificate has to be disclosed. And again, it has to be uploaded on RERA website. Title representation. Now, this is one of the very important aspect under RERA, which I think is a blessing to most of the home buyers. When it is a representation being made on a public domain, how much ever the developer wants to act smart, or the seller who is going to finally at the end of it sell the property to you, has to make sure that there is a decent title being displayed on the website. And on a public domain, you can't just put anything. So they have to make sure that the title is being explained properly. We spoke about standardization of the sale agreement and respective penalties that the developer might have to go through in case of not standing up to the promise that they have made to you under the contract. Thank you. Now, RERA is applicable to all the commercial and residential properties. There are certain provisions which speak about where it is not applicable. Let's not go there because we are concerned to what it is applicable under RERA. All of the projects which are not having received occupancy certificate as on 2017 comes under RERA. Now there is a little area of ambiguity, or the developer plays around certain aspects there. But having said so, as far as OC is not there, RERA should be there. That's what the law says. Any project which is less than 500 square meter need not go for registration, and if it has less than 8 apartments, again they are not required to go for registration. We can go to the next slide. Yeah, of course there's a procedure that all the real estate agents have to get registered, but that's fine. Yes, you might be having a lot of brokers who will be dealing with you, so even the brokers are supposed to be registered with RERA. In case of any default, when the complaints are filed, we can always get the broker into picture because of misleading marketing information that's been given to you. RERA also protects the buyers, wherein if there is any change, any addition, any alteration in the layout plan, or any kind of change in the project, after taking allotments, after taking down payments, they are supposed to take consent of two-third allottees. Now, this is an information which is really concealed, not practiced, while the law is there. But the developers, if they're not practicing, you have all the right to come together and go for a class suit. A class suit is basically when people come together and try to get their point or get their remedies out from the available legal provisions. So this is a point which most of us should be aware, and we should all be collectively, forming a group and being aware who all have made an investment in that particular project. And there cannot be any launch or advertisements without being RERA registered project. And Sharing of information, project plan, layout plan. This is basically all the disclosures and the transparency that the developer is supposed to make sure under the RERA provisions. You can go to the next slide. Now, these are the impact, like we have been discussing RERA for quite a few slides that we have gone in the discussion. Basically, timely completion. At the end of it, all of us want to make sure that whatever is the committed time, that needs to be ensured and delivered. Because of RERA, because of a lot of judgments that are coming in, time and again, RERA is reinforcing, making it very clear to the developers that you make sure either you do the timely completion or you pay for it. It's not the home buyer who should pay for it. So this is very clear under RERA, and I will urge each one of you to make sure that enforce your right. You have the right being vested by the law. Please make sure if there is anything which is going wrong, if the developer is trying to take you for a ride, make sure that you take proper legal assistance and get your duly compensation if there is a delay. Many times we have seen people who are being promised again and again by the developer, okay, it will just take few more months, and then you keep falling prey to those promises. Rather, I think you should know where to draw the line at the right time and reach out for the right remedy which is available for you. Formation of society, yes, there is a provision under RERA where it has been made compulsory for the developer to make sure that he forms a society or a welfare association and hands over to the existing members within 3 months after majority of units have been sold. Now, this is very important. Developers delay a lot of time because they are enjoying the money that has been collected in the light of maintenance. I'm sure people who are living in big, huge societies can understand the amount that is calculated. And the big problem that builders do is during handover. Lot of time we have seen they do not hand over the entire account to the society. So that is again something which the society is at the mercy of the developer. So it's might as well within 3 months it helps us so that he's not sitting on a huge fund for a long time, and this whole act is customer centric, so it's revolving around you. So this whole law has been made for you, so please be aware of the provisions of this law which is there for protecting the home buyers. Next slide, please. There's a concept in law, and even Constitution of India is very clear about this. Along with rights comes the duties. While we all are very, very particular, what are my rights under RERA? What do I get under RERA? At the same time, RERA has told you as an allottee, you as a home buyer, you should also make sure that while you're aware of your rights, you should also be aware of your duties. So here under the right, we have certain pointers that can help you understand what are the rights, which we've already spoken amongst the previous slides we spoke on. It's the right to information, which I said it's a very powerful right. You have information, you have rights to clear documentation, you have rights to obtain appropriate certificates, which includes your title certificate, it includes your completion certificate. You have right to claim for compensation. This is a very important right and very nicely drafted in the act. So there is no ambiguity. The developer cannot play around it. Right to withdraw from the project. This is a right you can use when you see that there is any kind of alteration which was not promised to you. We have seen projects where it was promised that there will be a building and there will be a garden, there will be a swimming pool in front of the building or the flat that you have booked, and by the time the property is given to you, you see that the whole thing has been used for parking. Mumbai has a big problem, and now most of the cities where the multi apartment buildings are being constructed, parking is becoming a problem everywhere. So they land up using the rights of the home buyer or the allottee, which was given to them, saying that this is an amenity you will be getting. It was your right because that is what was marketed to you, and that has been transferred, that has been altered without your consent. So you have the right to withdraw from the project there, and then there is some right of compensation also. You have the right to execute the registered document. Sate Karar is a document in Marathi, so it's a right to get a registered agreement in your favor after you paid 10% advance money. So this is a right that you as an allottee you do have. Let's go to the next slide where we can understand further into that. Here, like I said, with the rights comes the duty. So the duty that has been endorsed on the home buyer is before booking, you have to verify the developer's registration and the disclosures they have made. Not to buy an apartment in an unregistered project. RERA is very clear. It's trying to encourage as much as possible, please purchase property only under RERA registered projects. Even they have made provisions. Earlier, it used to have a provision where you have to pay some money and tell the government that this particular developer is taking bookings for a project which is not registered. Now they've removed the penalty, not the penalty, the fees they were supposed to pay. They've removed that, and they are asking people to come up and disclose or come up and raise an issue about the developer who's taking bookings in an unregistered project. So duty of a buyer is to make sure that he is helping the government to help you, and not to pay more than 10% of the cost without going for an agreement. Just this is an allotment letter. A lot of people, a lot of us land up doing paying the money. Abhi mere paas hai, we will pay and we'll wait for the stamp duty to be collected, because a lot of us have an issue about the down payment. Here, in fact, I would like to add the wonderful, fantastic product that Home Capital has come up with. This is one of the, I think, correct me if I'm wrong, Vaishnavi, you're one of the first in India who's helping you to do the down payment assistance.
Yeah, true.
Yes, and that's a really nice thing, Vaishnavi. I must tell Home Capital team that's a good product you've come up, because the major challenge is between the loan amount that you're going to get and the down payment amount that we are not able to gather together. Many a times we have like 8 lakhs is ready, but 10 lakh nahi ho pa raha hai. So that's the small difference which a lot of home buyers are not able to purchase their home. And Home Capital has stepped in to bridge that gap. And you're assisting home buyers with the down payment assistance, and I think some interest free amount also for the stamp duty registration, because all this starts pinching when you're purchasing a home. You have to have a huge down payment ready, you have to have your stamp duty ready. So all this Home Capital team can help you whenever you have a difficulty there. But like I said, the duty of an LRT is to make sure that more than 10%, if you are giving any kind of down payment or a booking amount, you make sure your agreement is registered. That's where RERA can help and protect you. So let's go to the next slide. Okay, so these are again explaining few more duties that you have to participate in formation of the society. We can take a skip because we are running out of time. I think we've already crossed 32 minutes. Yeah. Object of RERA we've been discussing. It's trying to set up a beautiful mechanism where entirely it's explaining how you can go step by step with all the complaints. We can go to the next slide. This is a very important question where many of the home buyers feel that why do I need to go and get the due diligence done when everything looks good? Itna acha builder hai, why do I need to do this? So I'm fine if the builder's name is good, let me go ahead. That's where I think somewhere probably we all need to rethink what are we doing. We are investing our hard-earned money into a project, or sometimes if it's a resale case also, you are purchasing from somebody whom you have not verified. It just the project looks good, the name of the person looks on the nameplate. If it's a resale case, you've gone to the society, you check the nameplate, his name is there on the nameplate, so that's good for you. But I'm sorry friends, you all need to rethink before you do this, because this is one of the very important neglected area in the real estate market. Two things: ownership and possession. Now these are the two things which may exist together or may exist independently. I know these are words which are a little very technical, and you would feel that this is a very legal concept that we are talking about. I'm sorry, there was something on my screen. Yes, but at the same time, ownership is a concept which is established only by the title documents, and that your lawyers or your legal experts can help you establish. Just by looking at the name of the person on the nameplate doesn't make him an owner. Just by looking at the name of the person on an electricity bill doesn't make him an owner. Just because his name is reflecting on a Sadbara or a revenue record, or whatever the document you may call in the respective jurisdictions other than Maharashtra, he is not the owner. He or she is not the owner. So let your legal expert help you decide who is the owner. Do not go by these documents. Maintenance bills, I'm telling you by my experience how people have fallen prey to the representations made by the seller by saying that my name is there on the electricity bill, so I'm the owner. That's not correct. My name is there on the property card, I'm the owner. That's not correct again. My name is reflecting on the maintenance bill I'm paying to the society. That's not correct again. My name reflects on the name board or the society's the list of members list. He's still not the owner. So please be aware of such traps. Second is possession. Maybe Vaishnavi is occupying a property for last 20 years. She's still not the owner. She's only in the possession of the property. So that's the difference. Who sells you the property? He should be the owner of the property, and preferably he should be in possession of the property. If not, if he is not in possession, suppose Vaishnavi is selling the property and Sujata is occupying the property, in that situation, Vaishnavi can sell the property, but Sujata has to give a NOC. That's important. Encumbrance. Another aspect is the property should not have any encumbrance. If Vaishnavi owns the property, she can sell the property, but provided she has not created any encumbrance on the property. Encumbrance means boja in Marathi, in Hindi and all other language, any kind of third party rights. किसी और का उस पर right नहीं होना चाहिए. So that is a situation where you or somebody who's checking the property for you, who's doing the due diligence for you, will make sure they check and they tell you. If there is a loan of any other bank, NBFC, any institution, first that loan has to be paid or their NOC has to be taken before you purchase the property, even before you give the token amount. My request to all of you would be, please make sure before you pay the token amount, in an excitement of a beautiful property, just don't land up spending your hard earned money to some seller who's trying to mislead you. We should all, it's good that we all trust the people with whom we are dealing, but it's also important you as a home buyer, you have to make a well informed decision. And thereby, point number 1 and 2 help you to come to point number 3, that is increasing your bargaining power or the negotiation power. If you know certain facts about the property, suppose there is a seller who's trying to sell you the property, but he got the property only by death of his uncle. In that case, there is a problem with the title. You will have a bargaining power. If he is trying to quote you very high, you can tell why your neighbor's property may be worth 2 crores, but your property has a title defect. So you can always negotiate. So while I do understand the question comes due diligence, why? Because there is a cost to it. But at the same time, it's giving you certain negotiation powers which can really reduce your cost in lakhs. While your lawyer might charge you few thousands, but this is what can be really an informed decision, and we say, increasing your bargaining power. Let's go to the next slide, please. Title verification is something which is very important. It allows you as a buyer to make sure you have established the ownership of the person who is signing your agreement as a seller. Encumbrances is what I tried to touch upon in the previous slide also. These steps will help you to avoid any future surprises. I'm sure when you buy a beautiful home, you want to stay in that and keep enjoying it all your life, and you want it to pass on to your next generation with the same pleasant experience without any surprises, any hiccups, any notices. Nobody likes those things. So please make sure you're doing your title verification before you purchase them. Power of the seller to sell is very important to be checked. Representation is one aspect. What we say and what the document says is different. So whatever your seller is telling you, good. Whatever your real estate agent, maybe your relative, maybe your friend, very close relative, friend, somebody, but let it be said in the document also. So if a seller says, I am the only person of this property who is the owner, let the document also say so. Many a times, husband says, I have the right to sell. He will never tell you that the property is held by two people, husband and wife. In this situation, seller cannot be only one person. Both of them has to sign the agreement, and you have to pay consideration to both of their accounts equally if it is not mentioned in the agreement. If specifically it's mentioned 60-40 ratio, then you may accordingly transfer the funds in 60-40 ratio in their respective accounts. You can't give the whole money to the husband only because that's how he's represented you. That's not correct. Coming to the power of attorney, many a times it's the POA holder who's selling the property to you. There are risks associated with this. One major risk is the POA holder, excuse me, the POA holder does not have the right to sell. He only has the right to register the property on behalf of the seller, the original owner. Now, this is what you really need to be checking very carefully before you give the token amount also. Because in huge properties or high value transaction, there is huge high amount of token amount that you give. Even if you paid like 5 lakh, 10 lakh token amount, it will pain you to take it back if the POA does not have the clause 1. Second, The person who has given the POA, if he or she is not alive, that POA is dead. The POA dies with the person who has issued the power. Are we connected, Vaishnavi?
Yes, ma'am, we are connected.
Okay. I see the slideshow has stopped. Thank you. So this is a very important aspect. If you're purchasing a property where the sale is through a POA, if you have not decided to do the due diligence before purchase or before giving the token amount, still you have not lost the time, please get the POA checked by your lawyers. If it has two things: one, the power to sell, the language should be very clear. He has the power to sell on behalf of the rightful owner and the power to register. And here, please ensure you transfer the amount only in the account of the original owner and not the POA holder. You cannot transfer the money, the sale consideration, to anybody else other than the owner of the property. Third point is the sale consideration to be paid equally to all the seller's account only. This we have already discussed. We can go to the next slide. How many minutes do we have more?
Ma'am, we can go slow, it's fine.
Okay. The next point is about the property documentation. Reviewing of all the documents. Now, what it in case of an apartment, it is the chain document pertaining to the apartment. In case of a land, it is the land related documents. Preferably, 30 years of chain is preferred in case of land. If not, because of any limitation, if you're able to at least produce 13 years of chain, well enough, but please make sure you are getting it reviewed. We have had cases which the value of the property runs into crores, but the current owner never bothered to really check the previous chains. One, he never bothered to even take the original chains. So please make sure when you are purchasing a property, you are checking the property papers and you are also collecting all the originals of the previous chain right from the date it is available. In law, we have a concept: go as back in time as possible. So please try to do that to make sure your right on the property is more and more stronger. Checking of the revenue records is very, very important. Property tax bills, especially for a property in Navi Mumbai now, it's very, very important that you check the latest property tax receipt, payment receipt. What happens is there are two documents that is confusing, and many a times the seller or the agents try to give you the bill, property tax bill. Now that is a bill raised by the authority. Somebody has to pay it, right? So you as a buyer, you will want to pay it only from the date, either from the date of possession or if you agree to some other date. But you will not want to take the liability of last 2 years, 3 years. And people who know there are challenges with different municipal corporations having certain disputes where the taxes have not been paid for 2, 3 years because there is a dispute with the tax authority or the municipal corporation itself. But why you as a buyer will want to take that liability which runs into lakhs? So please make sure the property tax payment receipts are checked before one you give the token amount, or if you land up giving the token amount, at least before you go ahead with the transaction. Please check the documents. Approvals are very, very important. There have been cases where the building is standing and it was realized that the particular flat which the purchaser was buying was not even approved in the plan. And after 10 years, my friends, it's very difficult to believe, but even after 10 years, there have been notices issued to demolish that particular flat only. You may have a completion certificate, you may have an occupancy certificate for the whole building, but did you check the plan where that particular flat is actually created in a fire area or an area which was allotted for some gym or a playground? Sorry, not a playground, but a play area for the residents of that building. So these are certain aspects which needs to be checked so that you don't get any surprises. Land use and zoning, this is more for the tier 2 cities or the cities where there is open area. Zoning needs to be checked. There are cases we have seen where the buildings or the property is developed in a no development zone. When it is not authorized to do development, you can't carry out development there. It's as simple as that. The language in the word is very clear. But still, there are cases where people have constructed and people have purchased. That's the failure of the due diligence exercise that you were supposed to do. We can go to the next slide. Buyers require to get these documents verified to the best extent possible. I do understand this all would require a little bit cost to be incurred, but so it be. It's just like doing a blood test. You will not avoid that 500 rupees which is required to do your blood test to make sure that everything in your system is going good. And same thing is to make sure that the building permits are in place, the environment clearances, the occupancy certificate, or the respective certificate is in place. We can go to the next slide. Inspection of property is something which is good to carry out to the best, because it's most of the, we have got cases where people are sitting in some other country and trying to book the property, and they liked everything based on a virtual tour. Now post covid and the new technology that we are all moving into, everything is becoming virtual. But unfortunately, my friends, there have been cases where something was shown on a virtual platform but something else was sold. So it's good to do a physical verification, or at least send somebody who is your trusted person to really go and check on the site what is the fact. Outstanding dues and taxes, like we discussed about the property tax receipt or any kind of inherent pending dues, that needs to be cleared before the property is given to you, or before you invest into the property. At least you should be aware what are the outstanding dues. All the future developments and infrastructure in the locality needs to be checked. We can go to the next slide. Now, this is where I was mentioning about the occupancy certificate we discussed. On the slide, the section and the law of the land is very clear, explained on your screen, which says that it is mandate under section 51 of MRTP, we call it in short, Maharashtra Regional Town Planning Act, where it says, no person shall occupy or allow any other person to occupy any building, structure, or part thereof unless an OC has been issued by the competent authority. Now, all of us are aware that hardly OCs are available, but we start going and occupying the property. Now, that's something which we are violating, and we are helping them to violate the law. What are the consequences? The consequences was a classic example most of us should be aware of. If we are not, I would request all of you to please Google out and read the case which happened in Kempakola. Kempakola is an area in Mumbai where there was a building and the OC was not issued. Without that, the building was erected and people had been occupying, and then the light, water, all this connectivity started giving issues, and authority went to a very large extent to decide that demolish the unauthorized construction. The case was discussed right till Supreme Court level. It's taught a lot of lessons to a lot of people. Uh, it also, of course, not having an OC has its own safety consequences. You have difficulty in obtaining home loan, and like we discussed, then there is eviction and demolition risk. We can go to the next slide. In the beginning, we discussed about one of the section which is there under Transfer of Property Act. This is the act which revolves around the entire real estate. So this act has very clearly mentioned under section 52, do not touch the property when there is a pending litigation. Why? The reason is there is a cloud around the title. So the title, who holds the title is not been established, and that's why the litigation is there. Many times, like in the beginning, I said there might be situations you can discuss the litigation and you may consider to purchase the property, because unfortunately in India, there have been misuse of available rights. While Section 52 is to make sure the protection of right of the purchaser or anybody who is going to deal with that property, people have misused this section to harass the other person to get his undue request sorted out from the rightful owner. In those situations, your legal expert can really help you to decide whether you want to consider it or not. But let's be aware what the section 52 says. You cannot touch the property unless the suit has been disposed of. That's very clear. It creates a hindrance between the rights of the buyer to enjoy the property as well, because you will keep getting time and again different notices coming in from different authorities. So that's why always avoidable. There is uncertainty around the ownership of the property. Like I said, there's a cloud on the title. This completely affects the sale price of the property. Let's go to the next slide. In the beginning, like we said, when you have knowledge in your hand, you have the power. So if you have power, you can discuss, you can talk, and the seller will Most of the time the seller is a little more stronger when he talks, because he thinks I'm holding the property, so I have the right to say more. But if you have the information, you will have more power. And at the same time, there's a concept in law which says buyer be aware. So, buyers beware is a concept which says that before buying anything, you have to be aware what you're buying. You cannot plead ignorance. Ignorance of law is not acceptable. So, you cannot say that I did not know. Why you did not know? Because you did not do your due diligence. So, please make sure that you are doing your due diligence, and then if there is a problem, law is there to take care of you. Law will protect you, but provided you have done your due diligence. So you cannot come to the court saying that I did not know, because you will have to prove that did you do your due diligence. Let's go to the next slide. So we've almost come to the slide, and probably Vaishnavi, if there is something more, I can share my inputs on any of the points. We will like to hear from you, and with that, we can wrap it up. And I leave everybody with a note that manifesting or purchasing of a property is a big dream for all of us. Let's make sure that it remains a pleasant experience for you and the next generation to whom you pass on. Which I would request, always do it through a will only. It's always helpful, and your next generation will always be thankful to you if you pass it on through a will. And for now, when you're purchasing, if you're having any difficulty, reach out to Home Capital with the beautiful product they have on your down payment. Thank you, Vaishnavi. That's all from my side. I'd like to hear if there is something more.
Yeah, we can. That was very informative presentation, by the way. I guess all the doubts and questions what viewers might have, everything is covered for now. But we can just ask the viewers or audience if they have any question. They can just ask us out. We'll wait for 2 minutes. We can answer those, and we are ready to wrap it up. Okay, we do have one question, which is, do redevelopment project needs to seek OC again?
Yes, basically, OC is a requirement to make sure that whatever has the approvals been given, if it has been complied with. So it is applicable for anything which is being carried out based on an approved plan. So the answer is yes. Sorry, Vaishnavi, I can't hear you. I think you're on mute.
Uh, Apology for that. Does redevelopment come under RERA?
Does redevelopment come under RERA?
Yeah.
Yes, yes, it does. There are certain provisions to it, but it has to be looked into a different aspect based on the facts of the case. But yes, it becomes.
Okay. One of our viewer asked, what is the period of stamp duty?
What is the period of stamp duty? Probably you've not been able to frame it properly. There's no period to stamp duty. There are rates of stamp duty which is described under different state laws, and the stamp duty has to be paid either before execution or maximum after one working day of execution of the document. The execution of document is calculated from the date both the parties have signed the document. I hope that answers the question.
Okay. She also asked that, should the stamp duty paid twice in the same year?
No, that's not the requirement. The law doesn't require any kind of double taxation. It's only once when you're doing the document.
Okay. Uh, so far, there are only these many questions.
Great.
If any other questions are there, I guess our viewers can drop it down. We have already shared the links and the mail handles. So, wrapping it up, thanks a lot, ma'am, for such an interesting session and for being our guide here today. Viewers, I hope all your questions and doubts are answered. If any are left, please comment on our YouTube video. Stay tuned for many more upcoming webinars with interesting topics. Also, don't forget to follow us on our social media accounts of Facebook, Instagram, Twitter, and you can also subscribe and rewatch our webinar editions on YouTube channel of Home Capital. We are
Thank
good
you,
to go.
Vaishnavi.
Thanks.
Thank you for the opportunity. Bye.